We can start. You can start.
Thank you, Stefan. Well, good morning, everyone, and welcome to the first webinar of the BRCC for 2022. I'm Neil McGregor, Chairman of the Chamber, and on behalf of myself and all my colleagues in the BRCC, may I wish you all a very hearty Lamuzan for this year. Best wishes for a successful and prosperous one, because the Chamber is about business, growing business. Now, this morning, this webinar is being recorded. And I'm telling you that for GDPR purposes. And if you're wondering why that should be the case, please keep listening, because this morning's webinar is given by my professional colleagues, Cristina Crețu and Daniel Alexie from NPR Partners on GDPR. There being three lawyers around the table, that's one too many. So I'm going to step back after this introduction is done and let Cristina and Daniel have the floor. Now, if you haven't been on here before, you will find that there is a chat box and a Q&A box in the bottom of your screen. If you have any questions, I'm sure you'll have lots of questions, please type them in the Q&A box or the chat box, and my chamber colleagues, Anna, Stefan, will keep an eye upon those and will bring your questions to the notice of our two speakers, and they will be able to answer those questions, I hope, in the course of their presentation. So that's enough from me. Welcome here, and Cristina, Daniel, thank you for giving this morning's presentation. I'll pass the floor to you and wish you the best of luck with your presentation. Thank you.
Thank you, Neil. Good morning, everyone, and a happy new year and prosperous one. I'm Cristina Crețu. I'm the Senior Technology and Privacy Consultant in NPR Partners. And before joining NPR, I was the acting DPO of UPC Romania. So I like to think that I know a little bit about the topic that we are discussing today. And I'm doing privacy starting from 2013. And now I will give the floor to my colleague Daniel to make the introduction, and afterwards we will start.
Hello, good morning, and have a wonderful and successful new year. My name is Daniel. I am a partner at NPR. I specialize, among other areas, in data privacy. I know Cristina from the time, as mentioned, she was in charge with privacy topics at UPC, and we collaborated thus in the client-lawyer relationship and now in the colleagues relationship. And I think her insight will be very valuable to this presentation from a practical perspective. And we hope you will enjoy our presentation and leave it with some new knowledge that may help you comply with your obligations under the GDPR.
And now we will start. I will share my screen. And just a second. So we are NPR Partners, as we mentioned earlier, and today we'll discuss about the transparency obligation under the General Data Protection Regulation. You might wonder why we are discussing this now. Isn't this a topic that was already addressed? Don't all the company have in place a privacy notice that, in their view, follow the requirements of GDPR? Well, taking into account the activity done by the authorities in Europe in 2020 and 2021, it seems that there are a lot of topics that need to be addressed in terms of informing the customers, and many companies, maybe they will want to reassess their privacy notice in order to bring them in line with GDPR. So we will start with the basic of an information notice. Why? Because why you need an information notice, because this is something that is required by GDPR under Article 12, 13, and 14. How you should start it? Well, by knowing what types of data you have in the organization. Getting things started will not be easy, and I'm talking from experience, and Daniel can confirm. We had the task of drafting a privacy notice in UPC, and I can tell you that it was not an easy job, because it comes the questions, what should we put in the privacy notice, how to make it clear, intelligible, easy to read, accessible for every data subject, how to take into account the structure of your data subject and his ability or her ability to understand what type of processing activities you are doing in the organization. So we started from having a template provided by the corporate, because we were part of Liberty Global, but we assessed in our team alongside with Daniel, and come to the conclusion that this will not respond to the questions of the data subject about what types of data we are processing, what we are doing with the data, what will be the legal basis for each processing activity. So we started from having processing activities, so we will do this and that for providing the services. We started describing the types of data that we will need in order to provide the services. We identified the legal basis and made mentions about whether we share the data with other companies or even if we transfer those data. And very important, we also mentioned for how long we plan to keep this data. So we started with keeping in mind that it needs to be easy for the data subject to navigate through our privacy notice. So if a data subject wants to find out information about a specific processing activity, then it needs to be easy for that data subject to identify that processing activity and to take from our description all the necessary information that will clarify what we do with our data. So yes, like I said, it's difficult to meet the legal requirements because you needed to make it short, easy to read, not to be boring. But at the same time, you need to cover all the requirements provided by Article 13, for example. So I will not lie to you, it's not an easy task to provide information in a concise, transparent, and easy to be accessed by the data subject. Another aspect that is important is who has this obligation to provide privacy notice. This obligation sits with the controllers. That does not mean that you cannot mandate another entity to provide you with a privacy notice. But bear in mind that that entity needs to know very well what types of activities you are doing, what will be your legal basis for processing, what you will do with the data, for how long you will keep the data. And I will give you an example, although it's not under GDPR. Recently, the European Data Protection Supervisor decided to investigate the European Parliament on how they provided information to the data subject in relation with some COVID testing facilities. And the European Parliament decided to leave the privacy notice on the processor, the entity that was providing with the testing capacity. But the processor, instead of understanding the type of regulation that applies in case of the European authorities, which is not GDPR, but has a similar content, took a privacy notice that was applicable in case of an airport and provided that privacy notice to the European Parliament to put on the website. The European Parliament didn't check the information contained there, and the data subject found that the European Parliament was processing personal data for example, under the legitimate interest provided by GDPR. So each and every time you plan to have a privacy notice drafted, bear in mind that whomever is doing this task is very well equipped in order to provide with relevant information. You need not to copy other privacy notice because they will not most probably reflect the types of processing activities you are doing. Maybe they don't have similar obligation that applies in case of processing activities. Also very important when using templates, you must ensure that you adapt it to your processing activities, to your data, to the level of understanding of your data subject. When you should provide for a privacy notice, if you collect the data directly from the data subject, then at the time of collection. But if you collect it from third parties, then you need to do the information within a reasonable period. But that depends on the circumstances of the case, and you need to also look into the exemption for providing this information. And later on, we'll discuss about reasoning provided by the Irish data protection in terms of what should an undertaker do in case Article 14 applies. So on drafting the information notice, the most easier information that you need to put there are the company details. You need to list the name and contact details of the company. And also very important, list the contact details of the data protection officer. In the past, there were some European data protection authority that considered that the privacy notice lacked information about the data protection officer. You don't need to provide name and surname of the data protection officer, but you need to have in place a generic address where, or a postal address where the data subject can address questions or exercise their rights. Then you need to put the types of data that are processed. And I know that Article 13 does not provide for the obligation to put in the information notice the data you are processing, because you are collecting the data directly from the data subject. But at the same time, there are many companies that have complex processing activities, and they use the data not only when they use not only the data provided by the data subject, but the data that is generated by the data subject by using the services. And in this respect, it's very important for the data subject to be provided with an overview of the data you are using when processing, when doing processing activities. You need to list the reason why you need personal data. So what's the scope of the processing? For what? For why you need those data? It is a contract. It is a legal obligation. It is you need to provide services. You need to comply with a legal obligation. You need it for purposes of marketing. You need to ship orders, so executing the contract. You need it for video recording and so on. And you need to provide the lawful basis. In practice, in terms of companies, the most used ones are the contract, the legitimate interest, legal obligation, and consent. And here it's important, and this is what we did in UPC. We took, like I mentioned earlier, we took the processing activity, we mentioned the data that we are using for that purpose, and we provide it with a lawful basis. Why? Because Article 13 mentioned that you need to provide the customer the purpose of the processing activities and the legal basis you relied on. So it's important for the data subject to easily connect the dots between what types of data, for what purpose, what processing activity, what lawful basis for processing. Also, Article 13 mentions that when you are using legitimate interest as a legal basis, you need to provide information on what's the legitimate interest and to whom this legitimate interest belong to. It can be either controller or a third parties or both. Also very important, and this is why we have a information notice, is the rights of data subject. You need to provide information on the rights the data subject has in connection with his data. You have the right to access the data, you have the right to be informed about the processing activity, you have the right to rectify the data, to ask for the erasure of the data, portability, to object to the processing activity, and you have rights in relation with automated decision making. And why it's important to provide enough information for the data subject in relation with his or her rights, because he needs to understand when and what right can exercise in connection with a specific processing activity. So for example, you cannot ask for the withdrawal of consent if your processing activity is based on contract, for example. You cannot object to processing when, again, the processing activity is based on a contract or a legal obligation. So always bear in mind that the data subject needs to understand how his rights are enforced, how these rights are applicable, because you cannot, if you don't explain it well enough, this will have a downside in the fact that you will receive a lot of requests from the data subject exercising their rights. And it happened in UPC, for example. Each and every time we provided the collection companies with the data of our customers that did not pay their invoices, the data subject came back to us and said, I never consented for you to send the data to a collection company. And that made us think that maybe we did not explain well enough how these processing activities take place and how these rights applies in practice. Because as you know, these rights are not absolute. Of course, there are exceptions from those, but this is for another topic. We also, you need to provide information about the recipients of data. You need to list the categories of entities with whom you share data with. And again, the European authorities have, they don't have a uniform view on this. There are authorities that said you need to list all your entities to whom you share data with. Some say that you can place it on categories and provide a link in case where, I don't know, you change your suppliers on a regular basis, and then it will be very burdensome for you as a company to amend the privacy notice each and every time you have a change in the entity with whom you share the data. You also need to think forward. Maybe your company will be subject to an M&A process, or where you need to share the data. You need to provide this purpose and provide enough information from the beginning, and that will ease your task in when you need to share data in a merger and acquisition process. Also very important, and you will see in the case we will present it today, you need to provide retention periods. You can't say we will keep this for as long as the service lasts, and then we will keep it for as long as necessary to comply with certain obligation. You need to provide either a specific date or or criteria that will allow the data subject to understand for how long you will keep the data. For example, in UPC, in terms of data related with the contract, we kept the data for the entire period of the contract, of course, and then for another 3 years, which was the period in which both data subject or other, in this case, other telecom operators might have had different disputes in relation with the amounts that were invoiced and paid. And now I will give the floor to my colleague, Daniel.
So I will give a few examples of enforcement actions taken against companies specifically for breaching their transparency obligations in Article 13 and 14 of the GDPR. What exactly did they do wrong and what should be avoided and how you should present your privacy notice and reflect it in order to not have similar issues. As mentioned by Cristina, it is very important in order to have privacy notice in line with the requirements of the GDPR for the same to be drafted based on very specific knowledge of the actual processing activities you undertake. So regardless whether you are doing it on your own or with the assistance of a lawyer, for example, this needs to be a team effort involving all parties aware of all your processing activities in order for not to miss something, to be sure if your legal basis is sufficiently strong to be applied, to see if you need to undertake legitimate interest assessments, and to be able to make the data subject comprehend the policy, to be aware of what data you are processing and for what reasonings and based on what legal basis. Because at least from our experience, we tend to see that data subjects are more willing to not give you any headaches from a data privacy perspective, such as making complaints before the authorities and so on. If you are very clear of what you are processing, why are you processing it, what's the benefit for the data subject, what's the benefit for you, and so on. It seems that certain large banks from Spain, such as CaixaBank and BBVA, and I will kindly ask Cristina to share the presentation, have not complied with their obligations under GDPR as regards transparency, as following a pretty large number of complaints from data subjects. They received inspections from the Spanish Personal Data Supervisory Authority, and they saw a plethora of issues, to say, regarding their privacy notice. For example, in the CaixaBank case, the information on data processing activities was provided using multiple documents and channels. From our experience, if, for example, all your processing activities are applied for all your data subjects as they receive the same services and products and whatever you may be providing them with, it's best to have a dedicated document for informing them on the processing activities, and it should be kept as much as possible separate from any documents. For example, and this was the case in this CaixaBank enforcement action as well, many companies tend to include their privacy notices in the contracts they sign with their clients, or in their terms and conditions that the clients must accept in order to be provided with the relevant products or services. And this somehow is not a very good practice, because it leaves the impression to the data subject that the privacy notice is complimentary from the company, that if they do not accept it by accepting the terms and conditions or signing the contract, they will not be provided with the services, that they cannot have, let's say, complaints against it. And this was also the case in the Caixa case. So our recommendation is to have a separate privacy policy, make it very clear that the same is basically a unilateral document and information, and it's not a bilateral document. It does not need to be accepted or signed by the customer. It just needs to be provided to him. You can provide it as an appendix to a contract, but when you refer to it in the main body of the contract, you should make them aware that it's a notification, basically. It's not a contract in itself. And then the other issues were, of course, related to how the privacy policy presented the processing activities, namely in very vague phrasing such as may process all personal data generated in the contracting and operation of products and services, or using expressions like such as or etc. and so on. Such types of wording should be avoided. As mentioned by Cristina, while Article 13, when we are of the GDPR, when we are referring to personal data obtained directly from the data subject, while the article does not expressly require you to provide the categories of personal data that you are processing, from our perspective, and as shown in cases, in case law as well, we think that it's important to actually list them, if not required expressly, because this is how, in the end, the data subject is truly informed of the processing, and this is how you can basically demonstrate that you have complied with your transparency obligations. And another way of presenting this information that should be avoided is, for example, there are lots of, I have seen lots of privacy policies that simply reflect all personal data. We process the following data: name, first name, last name, email, address, so on. Then they list the purposes for service provision, for marketing, and so on. Then they list the legal basis: legal obligation, contract, legitimate interest, consent, etc. This is not a good way of informing data subjects regarding your privacy, your processing activities. From our perspective, the best way to achieve full transparency is to separate each processing activity, present the personal data processed for each separate processing activity, the legal basis for each one, and so on. Yes.
Daniel, I would like to add that in case of one of the banks in Spain, they provided an argument to the authority that the privacy notice was read by a linguist, and therefore they ensured that this this privacy notice is easy to be read by a data subject. But although a linguist ensures that you use the proper terms and you use the proper grammar, that does not mean that you will be able to communicate to the data subject the information about your processing activities. The best way, like you mentioned, is to involve all the relevant stakeholders within the company and provide them with the privacy notice and ask them to read it, and to read it through the eyes of a data subject. Actually, you should start writing the privacy notice having in mind that you are a data subject. If you get bored or if you get lost in the expression you use, then maybe you should return to the basic and start over. So what we did in UPC, and you remember, Daniel, after we drafted the initial privacy notice, we provided the document to you and to relevant departments within the company that handle the data subject. So to customer experience department, to PR, in order to provide their view, because they were the ones knowing better the data subject. And it's mentioned by one of the authorities that applied fines in relation with privacy notice, that a diligent company knows its customer.
Yeah, so basically it's important, as Cristina said, to know your customer prior to making the information, to adapt it to your relationship with the same. And should you also obtain assistance from lawyers or other consultants, it's best to avoid legalese and any complex terms use the simplest words you can identify in order to send your message as clearly as possible, and make sure before actually publishing or sending the privacy notice that you first of all understand it and your colleagues understand it. It's best to share it with as many people as possible, because through this team effort you can correct any potential issues or misunderstandings that the document may generate. And Cristina, I saw that we have 2 questions.
Okay.
Should we answer them now?
Yes, I can't see it because I'm sharing the screen, so I would like to ask for your help in the question.
Our first question is, in the future, modern privacy laws will cover the personal information of most of the world's population, over 75% by 2023. In this case, how will companies be able to manage the multitude of data and ensure its security as well, given the threat of data breaches?
Yeah, this is 2 separate topics, because Article 13 does not mention anything about security. So whatever you are doing in terms of securing the data, you need to do it in the organization and make sure that the data are kept secure and are not subject to attacks. How you will deal with this amount of data? By knowing what types of data you are using and deciding what types of data you really need, because this here will come in place also the data minimization principle. Do you need that data? If you don't need it, don't use it. And therefore, it will not be reflected in the privacy notice. Don't gather all the information you have access if you cannot provide for a legal basis to use that information, for example. So, like I said, when I started this webinar, it's important, first and foremost, to know your data, to know your organization, to ask questions, why do you need it? Do I really need it? Can I? If the answer is, I will need it in the future, okay, but at this point, you don't need it. When you need it in the future, because this privacy notice is a living organism, you don't write it once and then you forget about it. Each and every time a new processing activities will add to the other processing activities, you need to look, what types of data do I need? Do I have a legal basis for that? What I will do with the data, and afterwards inform the data subject about this. So how I see this amount of data that comes towards us is looking specifically at the moment when I'm doing some processing activities. Don't think for the future. That's why expressions are like, we may process your data, are not accepted by the authorities. You might do it in the future, but when you'll do that? So stick to the present, choose the data that you really need and for which you can provide proper justification, and reflect that in the privacy notice.
Yeah, so as Cristina said, it's important to actually identify what data do you need. The fact that many companies will deal with large amounts of data to process and thus manage and be transparent about and avoid breaches, in the end, is the result of the company's activities. And thus, in order to minimize risks, you should also minimize data, as is also required under GDPR expressly. Sorry to intervene, but I understand that the presentation is not visible, and
I don't know why, because I see it. Just a second, I will try to reshare it once again. So I will stop the sharing. Okay. Now you can see it?
yes, I can see. Okay, and we have a second question. Namely, will sanctions become more stringent for companies that fail to comply with GDPR rules in the future? From my perspective, fines are already beginning to be larger in numbers and in quantities, because basically the GDPR is now in force for almost 4 years. So most likely the authorities are already expecting most companies to have complied with their obligations. Plus, the public is more aware than ever than as regards the actual obligations that the data controllers have, and thus are more willing to actually exercise their rights and make complaints when necessary. And from my perspective, but Cristina can share her point of view as well, the answer to the question is yes.
Yeah, it depends here, because up until now we see two types of investigation. The ones that were in connection with a single complaint, and the authorities didn't go beyond that complaint, so therefore the amount of fine was smaller. And then we have this type of fines that actually investigated the way the companies observe the data protection requirements in relation with all the customers. So in this case, if more investigation like these ones will be opened by the authority, yes, we'll see larger fines. So it depends. And again, we have that one-stop shop, and a lot of big tech are in Ireland. So that single authority needs to investigate huge companies that process huge amounts of data. So in those cases, the investigation takes longer. Then you need to go under the cooperation mechanism. So like a lawyer likes to say, it depends. But for sure, we will see more and more actions taken by the authority. And a couple of days ago, a statistic on the GDPR fines was published, and the number of fines are increasing each and every year, and the amounts are increasing each and every year. And I would like to also add, in terms of I hope this answered the question. Do we have other questions, or we can return to the...
Well, I think we can connect this question to the first question as well. And regarding the large quantity of data subjects and personal data categories that the companies will be processing in the future, as has also been the case with the 2 fines in Spain against the 2 large banks. The amount of the fine is sometimes directly connected to the number of data subjects you are, whose personal data you are processing in breach of the GDPR, and the large number of personal data categories. So minimizing can also lead to smaller fines, and large processing can lead to large fines. But yes, in principle, this will be, depends on the actual case and on the findings of the authority and its own interpretation of its role in this.
And again, returning to the fines, so even the Spanish authority recognized that when you have complex processing activity, then it will be more complex to draft a proper information notice. But they consider that this is not impossible, because you need to provide a more degree of detail in terms of processing activities and data. And when you have complex processing activity, you need not to think that you'll have a lengthy privacy notice. So you need to provide with information that will be effective for the data subject to exercise their rights, because this is what privacy professionals are saying, that you don't need to draft this privacy notice thinking of you. You need to draft this thinking of allowing the data subject to understand what you do with their data, and if the case, to be able to exercise their rights. And in case of one of the banks, for example, they had 2 processing activities entailing profiling, each one of them based on different legal basis. One was on legitimate interest, the other one was on consent. And it was without providing specific details for each of the processing activities. For a data subject, was difficult to understand if it is profiled by the bank, although the data subject did not provide the consent, or another legal base was used by the company. So you need to make sure that you link all the data and purposes and the legal basis, and provide enough granular information for the data subject to be properly informed. Should we move to the Carrefour, Daniel?
Yes. Another case where large companies were fined by the public authorities for infringement of their privacy obligations was in France. 2 Carrefour companies, namely Carrefour France and Carrefour Bank. Basically, here we had again issues similar to those in Spain, like very vague expressions. But here also they failed to inform the customers about certain processing activities and certain personal data that were transferred amongst the companies of the group. And in addition, it was very hard for the data subjects to actually access these privacy policies. They were accessible on the company's website, but somewhere at the lower part of the website, under names that were not clearly reflected that they are dealing with the privacy policy. And basically, customers needed to scroll through dozens of pages in order to identify the policies and their rights under the GDPR. So besides actually identifying your processing activities clearly, reflecting all of them, all categories of personal data, the legal basis and so on, it is also very important for this information to be easily accessible for data subjects. So depending on the manner you inform them, for example, in our case with the UPC, these were sent via post to all customers and also published on the website. It is important to be straightforward and, let's say, proactive towards the customer. You need to help them to identify the policy, to make it as accessible as possible, both from a language perspective, but also from a accessibility perspective, in order to avoid issues and sanctions. And as already mentioned, it's best to have this in a separate document, separated from contracts and terms and conditions, in order to comply with your obligations under the GDPR as straightforward as possible.
It's also very important not to make it tedious or boring. These were the exact words of the French authority, that the privacy notice in this case was tedious to be read even by an informed person. So even for someone who had some knowledge in terms of data protection, this privacy notice was difficult to be read and understood. And another thing that was discussed by the French authority was the data retention. which was very vague. It did not provide the data subject with a full understanding about the period of times this data will be held. And if you have the curiosity to look, the Carrefour amended their privacy notice, and now information about their data retention, about the retention of the data, is provided in a table, which makes it more easier for the data subject to understand for each categories of data the period of time for which the company will need to keep such data.
So even if you maintain the data, let's say based on a legal obligation, because in Romania, for example, there are very clear retention periods for certain documents, such as invoices that must be kept for 10 years. Even if you have a legal obligation to maintain the documents containing the personal data for a certain time period, it's insufficient to have wording such as we will maintain the personal data in accordance with the period established by law. You also need to specify it. That way you can be fully transparent and not have issues regarding this topic, because in the end you cannot expect the data subject to actually go through laws to confirm whether you have a legal obligation and to identify the relevant period. You need to make it as easy as possible for them and minimize any questions they may have on your privacy notice. And moving forward from this, we have another question, which asks us, how big are privacy notices? How many pages? I think this depends on the actual activities you undertake. So if you have a large number of processing activities, you will have potentially a large privacy notice. But at the same time, as Cristina mentioned, this does not need to be tedious and hard to read and comprehend. So you can use, for example, you can have an overview where you present the obligation that the information that you need to provide under Article 13 of the GDPR. And then let's say have a link for additional information, but it's also very important when you do this to make sure that the essential information required under Article 13 is presented in the overview. Or you can use other methods to minimize wording. You can have tables, you can have images next to the information to exemplify it in a small space as possible. But in the end, this will still depend on your actual processing activities. I think the one we assisted on, Cristina, for UPC had around 10 pages.
No, 6. It had 6 pages, and you can use a layered approach. And providing like Daniel said, providing the essential information in the first layer, and then providing with details for those data subjects that were interested in knowing more. But you need to ensure that you have consistent vocabulary. Even if you decide to have a general privacy notice that explains at large the processing activities you are doing in the organization, and for specific points of entry you have specific data privacy notices, you need to be consistent. If you talk about, you use a certain word to define a certain specific processing activity, you need to use the same wording across all the documents that talk about that processing activity, because this was also the case in the sanction, in case of one of the banks, the fact that they use a lot of synonyms in describing the same processing activities, which ended up being confusing for the data subject, because it created the impression that the bank had different processing activities when in fact it was the same one mentioned in the main data privacy notice. So it's important if you want, yeah.
So if you have, let's say, references in other documents to your privacy notice or so on, and you update those documents such as your terms and conditions or a contract or a more general type of information towards customers, you need to make sure that when you update them, you follow the same wording you have in the privacy policy, or if updates are truly necessary to the privacy policy as well, you need to update all documents that may refer to those processing activities in order to avoid confusions between.
Yes, in this case, actually, it's not important that you repeat yourself. Actually, it's important to repeat yourself and to be consistent. You don't write a book, a novel, where you need to show how many synonyms you know about a specific word. Here, you need to be clear and to use the same wording. And if there are no other questions for now, we will move to another fine, which was quite an amount of money, in quite an amount, like 225 million euro, provided by the Irish Data Protection Authority to WhatsApp. And in addition, because again, we don't talk enough about, we talk about fines, they are huge, but think about the efforts and the time and the money needed to align your privacy notice to the requirements of GDPR. When an authority comes and say you did not do a great job. In this case, WhatsApp had 3 months to bring in line their privacy notice with the findings of the authority. And I would like to emphasize on an argument provided by WhatsApp. They say we have the same level of detail as our peers, meaning that we do the same as the whole market. Why do you think this is wrong? Because the whole market does it the same. And the authority said this is not a valid argument. It doesn't matter that others in the market are doing the same. You are not allowed to provide with to set up the standards of compliance, you a private organization. It is us, the authority, and it is GDPR that sets the standard for compliant data protection, data privacy notice. And I met this way of thinking in UPC. The others are doing it. Why we cannot do the same? It doesn't matter. We are responsible for the compliance of our organization, and we need to take into account the risk we are exposing the organization. The fact that the others are doing it will not exempt you from getting a fine. And in case of WhatsApp, the findings were quite similar with the ones of the Spanish and French authority. The difficulty of the data subjects to navigate through the information. They provided a lot of links, but they were not connected, and it made scrolling, like it made the impression that you need to scroll and scroll and you will not get to the bottom of it. It left the data subject with the impression that maybe there is more information about how WhatsApp processed the personal data. It didn't create the feeling that, look, this is the whole information, this is the overview, these are the links where you can access for more information. And once you finished all this, you will find all the information needed about how we process the data. In case of WhatsApp, the Irish Data Protection Authority specifically mentioned that the data subject must be able to identify the legal basis for each processing activity, and you need to link the data you are processing with the purpose, with the processing activities and with the legal basis. It's like in school, if you remember, you had the phrases on 2 columns and the teacher asked you to connect the phrases that make more sense. This is the kind of information you need to provide to the data subject. It needs to be able to rapidly connect the dots between the data you are using, for what purpose, what types of processing activities you are doing, what will be the legal basis. And the fact that you are using those wordings for providing measurement, analytics, and other business services, but what does this mean? What do you do in order to provide with this? And what types of data, how will you use it?
To whom you will send it?
Yeah, who will send it? Again, it's important, and they made reference to the companies with whom you share the data. It's not sufficient to provide information that you will share the data with third-party service providers. At least you need to list the categories of service providers. Either they are collection companies, or postal companies. It doesn't matter. You need to put it at least in a category. If you don't have the name, or you are not using a single provider, which will make easier to put it in the privacy notice. And this is also something that it's similar. And again, another problem was data retention. We keep the data as long as you use the service. This creates the impression that you'll delete the data after the data subject no longer uses the service. But at the same time, WhatsApp kept the data for a longer period of time because it had other obligation for which needed those data. And I was saying at the beginning of the webinar that there is a good news in terms of Article 14, because here the Data Protection Authority investigated both the compliance with Article 13 and Article 14 for non-user of WhatsApp. And in the case of non-user, the Irish Data Protection Authority came to the conclusion that it will be an impossible task for WhatsApp to provide information to each and every user. So it will be enough to have it on the website. And now to the next. Here it's a proposal for Facebook to be fined between 28 million and 63 million. Most probably after the cooperation mechanism, this fine will also increase, because in the previous case, the initial proposed fine was around 50 million. But following the consultation with the other Data Protection Authority and with the European Data Protection Board, the amount of fine increased to over 200 million euros. And here, the subject, it's a little bit more complicated because it also entails the legal basis for processing Facebook data. In this case, it is either consent or contract. Up until now, the Irish Data Protection Authority considered that it's contract, which is kind of a good news for, at least for Facebook, because it covers also the targeted advertising, but also in connection with the information provided to the customer, and with focus on the purposes and the legal basis, because this was an entire discussion that was valid also in case of WhatsApp, that that GDPR does not prescribe the obligation to provide information on the scope of the processing activity and the legal basis in the same context. So for the data subject to properly understand what's happening with that processing activity and why it is happening. And for example, it is mentioned in Facebook that you need to provide the categories of data, the purpose and the legal basis, and you need to link it together in order to be easy for the subject to understand. And in case of also in Facebook and WhatsApp, they used the same wording to reflect processing activities that have different legal basis. It was for purpose of security and integrity, and it was based on contract, on legitimate interest, and providing for the vital interest of the data subject. But the wording and the lack of granularity in explaining this type of processing, this type of activity and this type of objective to ensure the security and integrity of the data did not allow the data subject to understand when the processing had as a legal basis the contract, because it did not provide that degree of granularity, when the processing was based on the legal obligation, and when the vital interest, because for sure there were different processing activities entailed. For sure there were different data entailed in ensuring each of those objectives related with security in relation with those legal bases. Because in practice, the authority considered that you cannot have for the same purpose more legal bases than one, because it will be difficult for the data subject to understand how to exercise his rights in relation with that processing activities. So what you can have is a big objective, ensure security, but then for sure you have sub-purposes, and for each sub-purposes, indeed, you might have different legal backgrounds.
And you might have sometimes indeed processing activities that are fairly similar. For example, you may process your client's interactions with your website for marketing or profiling, and at the same time you may also capture these interactions while you're verifying your website for security. So yes. This is the type of situation where you might need to provide a bit more information and details regarding these two processing activities. For example, in order to be able to differentiate between them, the legal basis and the purpose, and so the data subjects can understand these differences even though they're very similar. And you need to identify how you provide these additional details while also complying with accessibility, ease of reading, and so on.
Yes, and as a conclusion of the cases we presented today, make things easy by removing all the necessary information in a privacy notice. In case of Facebook, for example, the authority mentioned that it is okay for Facebook to provide additional information, but this needs to be in the background. So first provide the relevant information required by GDPR, and then you can provide other information, but make it in such a way not to be difficult for the data subject to read. Don't put it between the processing activity information that is not relevant for the
or not required, because
yeah.
Sometimes you can lose like half a page of a privacy notice by general warnings such as we value your personal data
yes.
and privacy, we take security measures, there are such and such, and so on. Focus on what you have on Article 13, and if necessary from a marketing perspective, to also provide the other information you want to share. You can have them in a footnote or at the end of the document, or you can have them as a
separate page, for example.
Page where you link to the privacy notice and so on. You can maybe use it as an introduction. here we value your privacy and security of your personal data. And thus, please click here to see our privacy notice, for example.
And talk about what you are doing, not about what you are not doing. For example, if you don't share the data or if you don't transfer the data, don't mention that in the privacy notice. Don't do it.
It will only make data subjects suspicious.
Exactly. So keep it to the subject and provide only the relevant information. Actually, write first the privacy notice, share it through the organization, and then open it days later and start to cut the necessary phrasing in a privacy notice. It will not help you. It will make it difficult to read. It will sometimes bore the data subject and make it interesting. And most important, write it to be addressed to your data subject. So if your data subject it's in a certain categories of age, or it's a millennial, it's a generation X or Z, adapt the language to your data subject. You need to talk more personally, maybe you need to talk more, I don't know, informal in some cases. Use it. Don't use the same pattern, so the same structure, not thinking about your data subject. And this brings us to what you should do and don't do. In our view, and we explain why it's important, and it seems that the authorities are agreeing with the approach we take in 2018 with EPC, mention the categories of personal data that you are using. Of course, the data subject provides you with the information, but then there are a lot of data that derive from that information. And in many cases, maybe the data subject does not have a clear view on the vast amount of information you are having about it or generating about him or her. Mention the purposes and the legal basis in the same place to be easy for the data subject to link those between them.
We process your, I don't know, credit card information in order to be able to make sure that your obligations under the contract are complied with, so on, based on our legal obligation to issue an invoice, for example.
Yeah, so use super precise and easily understandable terms. I know it's hard. It was frustrating. It was with a lot of nerves. It was difficult. It was not an easy job to first draft the privacy notice. Avoid information fatigue. Try to use layered approach. Try to connect the information. Keep the same language throughout the documents. What to not do? Don't rely on long texts that are difficult to comprehend. Sometimes, like we mentioned, you will have long text. But if you split the processing activities and provide all the relevant information for a specific purpose, for a specific processing activity, you will allow the data subject to just go to the information that it's relevant for him, or where that data subject needs more information. That although you will have a lengthy document, it will be easier for the data subject to navigate through the same. Don't forget to regularly update your privacy notice. Like I was mentioning, it's a living organism. You don't write it once and then you forget about it. You need to come and revisit, sometimes because you found out that maybe the data subject did not properly understand your processing activities and created a lot of requests for them in order to clarify, or a lot of exercising of their rights. Yeah, so maybe come and adapt the wording to make it more clear. Each and every time you have a new purpose or a new processing activity, come and update the data privacy notice. And another important don't, as Daniel was mentioning earlier, don't ask individual to consent or to
Or accept
accept
or sign or so on.
or sign your privacy notice. This document is intended to inform the data subject about your processing activity and to enable him to exercise his right. Yes, it's not to approve of your privacy notice, it's not to sign it, it's not to consent to it. Yes, it's just for information purposes as required by GDPR. And I think with that, we finished our presentation today, so we can take other questions in the remaining time. I will stop sharing my screen now. So do we have other questions? No one?
I think you've obviously made such a an impression on everyone that they're trying to absorb all the information you provided.
We hope so. We hope we didn't, at least I hope I did not speak too fast. And I hope I was clear in, it's not an easy subject, and it's not easy to talk about privacy sometimes.
Well, if you have any questions, don't keep them private, do share them.
Yeah, do share it with us. And apologies for, I thought that I shared my presentation from the beginning, and afterwards I was not able to see your cries of help that the presentation is not visible. So sorry, we'll need to find other mechanism in the future.
People may remember that we were fortunate to have a presentation by high-level people in the Information Commissioner's Office from the UK, who came out to Romania when Romania was in the chair of the European Union. And that was a very well attended face-to-face event of the chamber. Once we could have face-to-face events, I hope we can go back to doing. Obviously, there's interest in this area, particularly now following Brexit. We're no longer part of the EU's, should we say, safe harbor.
Yes, but UK still has the adequacy decision, so the transfer is rather easy as opposed to other third countries. And up until now, UK GDPR and the EU GDPR are the same, with slight amendments in terms of local specificity under the Data Protection Act, but we share the same value.
Is anything particularly required to share information from Romania to the UK or vice versa?
So transferring from Romania to UK will be done under the mechanism of the adequacy decision, but with the exception of the immigration information, which is not covered by the adequacy decision. It is a problem under the UK law, and it was addressed in the court, and I know that now the British government is trying to amend the law in order to bring it in line with the court decision and to align. I don't know what will happen afterwards if the European Commission will also include the immigration legislation under the UK adequacy decision. And from UK to Europe, I think it's also an adequacy decision, but it's more, it's a little bit different. I don't know, to be honest, I don't know the difference between those two, but at least it is a mechanism for data to go from Europe to UK.
It seems to be a matter more of form than substance, given that I think both jurisdictions have, should we say, adequate safeguards. Yeah,
for now, because I know that the UK government intends to amend the UK GDPR, and we will see how this will sit with the European Commission and how it will affect the adequacy decision. But it's easier, it's easier than the standard contractual clauses and to perform a transfer impact assessment, to be honest, and to take supplemental measures.
Right, do we have any other questions, please?
I think not.
Well, in that case, can I thank you both very much indeed for your excellent presentation, and I think you've held a very good audience today, so well done there.
Thank you.
Thank you.
And if you have any kind of feedbacks, what we can improve, please provide it through Anna maybe, or we will take it into account for our next webinars.
Thank you. And talking of next webinar, if you look in the chat box, I'm just putting up the link to our next webinar, which you want to click on that and have a look, is upon trading opportunities in Romania and doing opportunities in Wales, Țara Galilor. This is in conjunction with the chambers in Wales. And again, is another example of the power of the BRCC in using our connections with the members of the British Chambers of Commerce and the global network. So this will be on the 25th of January. It's online again. You'll see that there's a lot of very good supporters there. And it's another example of how we're looking to promote trade between the UK and Romania, as well as investment. So I hope we'll see you at that, as many of you as possible. You'll also know we have two face-to-face events. We have a gala, I think on the 27th of January here in Bucharest. And on the 31st, there will be a reception held at the House of Commons in London. And so if you can't go to one, please try and go to the other. If you can get to both, it's even better. But it shows we're getting back to some degree of normality with face-to-face events again. We're not going to stop doing these online events because they're a very good way of giving everyone access to expertise wherever you happen to be located in the world. So on that basis, can I again thank Cristina and Daniel for your presentation.
Thank you very much for having us.
Thank you for having
Thank
us.
you to Stefan and Anna and many of my colleagues in the chamber for organizing this. And thank you all for attending. Să aveți o zi bună în continuare și ne vedem pe 25 ianuarie la următorul eveniment. Mersi frumos și aveți o zi bună.
O zi bună. Bye. Have a good day.